I was very pleased to listen to discussions held at this conference, the polemic between Professor Pulygin and Professor Alexy, and testimony once again that what Leibniz once put in this way: he who interprets the thought interprets not only the enunciation, but even more the person who enunciates it, supplying what the latter said in an imperfect way. However, he supplies not according to his own thought, sentencia, but according to the thought of the speaker. An artist of last century, Arnold Schoenberg, illustrates these ideas in an extraordinary way. His opera, Moses and Aaron. His opera presents Moses and Aaron, polemic about how to reproduce God's laws. Moses says God's words to Aaron, and Aaron then sings these words to the people. Moses gets mad with Aaron's imperfections. In the opera, Aaron and everybody sings except for Moses, who only speaks. It illustrates a very insightful way the tension between sense and sensibility, the sentiment of justice, in the interpretation of law. Moses says, the people must understand the idea. They live solely for this. Aaron sings in disagreement. But no people understand but a fragment of the idea, of the image that expresses the inconceivable portion of thought. The inconceivable emotional dimension is just expressible by melody, sensibility. Why I'm talking you this? First, to point out to the irrational element present in spite of our efforts of rationalization of the legal phenomena. Second, to thank Jordi's and Juan Pon's invitation and warm friendship. And third, to introduce the talk by Brian Bix, who has been brilliantly struggling with the challenges posed by legal interpretation. Please.
I'd like also to thank very much Jordi Ferrer for the invitation, the University of Girona, Matteo Pons, and all the other sponsors and organizers of this amazing gathering. I'd like to also pass on my respect and admiration to all of you. As has been pointed out before, we would never have a gathering of this size in the United States to talk about legal theory, and people would have gone home a long time ago, days and days ago. I thank you for the kind introduction and for the reminder that I represent the irrational element here today. What I do represent in this paper, this is a first take, a preliminary effort to come to grips with some different approaches to legal theory, different from my own, that I'm trying to understand and evaluate, because many of them are relatively recent, and I hope with the help of your comments to move forward on these ideas. One persistent mystery of jurisprudence is the wide range of theories about the nature of law, even if one only includes theories that have been put forward by well-regarded theorists and have at least to some extent survived the test of time. If we are all theorizing about the same subject, law, and one that is well known and mundane, not esoteric, why do the theories vary so much? One basic disagreement seems to come at a foundational level regarding what it is that theories of the nature of law are describing, analyzing, or explaining. Does the theory explain the practice of law? And if so, is it the practices only of our legal system or a select number of similar legal systems? Alternatively, is the theory explaining an idea or ideal of law that transcends current or past practices, perhaps a Platonic form or some moral or political ideal? This paper will offer an overview of the different approaches to theorizing about the nature of law, focusing on the justification and value of theories grounded in ideals or objectives. The first part discusses how many mainstream theorists have transformed theorizing about the practice of law into theories about the concept of law. The second part offers a quick overview of a number of theorists who offer theories fairly characterized as based on an ideal or teleology of law. The third part revisits some basic methodological issues relating to the evaluation of differing approaches to legal theory before concluding. Jurisprudence articles, books, and courses often focus on, or at least begin with, what are described as theories of law. However, it is only on rare occasions when it is made clear what is being explained by the theory. Is it the particular institutions and practices that go under the label law or legal system? That would seem the obvious response, but it immediately raises problems. If the theory extends beyond the theorist's own legal system, after all, it is usually labeled a theory of law, not a theory of American or English or Spanish law, how do we know which normative systems are included and which are not? In other words, if the theory extends beyond a single identified normative system to a group or category of systems, then there needs to be some way to identify the category, to determine the boundary lines. As Scott Shapiro noted earlier today, one cannot go simply by the term, here the English word law. First, because this term, like most if not all labels, has uncertain and imprecise boundaries. And second, because communities where English is not spoken may not have a word which corresponds sufficiently to law. The term in the local language may be broader or narrower or overlap only in part. One alternative is that perhaps something entirely independent of us can ground the category law. In other areas of philosophy, this external grounding might be a Platonic form or idea. That there is a category law in some other realm, of which all legal systems in the history have only been imperfect realizations, just as all present, past, and future existing leaves are only imperfect realization of Platonic idea of leaf. As an alternative advocated, to varying degrees of explicitness, by H.L.A. Hart, Jules Coleman, Joseph Raz, and others, is that the proper focus of a theory of law is the concept of law. Thus is Hart's famous book on legal theory called The Concept of Law. However, it is Joseph Raz who has given the most attention to articulating the nature and justification of conceptual analysis as a methodology in jurisprudence. Rawls has argued that theories of the nature of law are theories explaining our concept of law. There are no significant metaphysical assumptions to such a claim. A concept is just a thought category that helps us order our world. For conceptual analysis of this sort, we do not need to assume, with the Platonists, that there is some object in another realm of existence that the concept tracks. Nor need we assume, with the natural kinds theorists, that the world somehow sets the boundary for the category the concept names. At first glance, then, conceptual analysis is primarily a matter of identification and boundary lines. How do we determine what is inside this category, law, and what is outside? Through conceptual analysis, we ascertain what the essential properties are, in this case, the essential or necessary properties of law, keeping in mind that essential and necessary properties here refer to nothing more ambitious than the criteria our concept sets for the category in question. Additionally, Rawls argues, our concept of law is part of our collective self-understanding. Theorists are not free to choose just any concept of law, for example, according to its usefulness in social scientific research. As our concept of law, the concept is parochial. Other communities, past and present, have had different concepts. However, as a concept that we can and do apply to all other communities, present, historical, and hypothetical, the concept is in that sense universal. The connection between the concept and the objects or practices referred to by the concept are not easy to delineate clearly. Nigel Simmons once asked whether our concept of law was, quote, true to the nature of law, unquote. But this assumes that we can speak of the nature of law separate from our concept or our concepts, and that may not be possible. Of course, one can criticize a theorist for misidentifying or misdescribing what our concepts are, but the concepts themselves seem to be, in a sense, beyond criticism. However, if one focuses on the way concepts interrelate, for example, according to Rawls, that our concept of law is connected in basic ways with our concepts of authority and our concepts of reasons for action, there does seem potential grounds for criticism. For example, that a concept does not fit well the practices it purports to describe and demarcate. Additionally, a focus on concepts for a practice is unlikely to pick out the consequences, the concepts for a practice like law is unlikely to pick out the consequences in the world of the practice the concept names. At least the concept will not pick out all such consequences. This ties in, I believe, with Scott's points earlier, the difference between necessary elements of concepts and their implication. One response is this merely reflects a difference in disciplines or a difference in projects. That in our conceptual analysis, we are doing philosophy of law, not sociology of law. In a series of papers, Brian Leiter has challenged the use of conceptual analysis in legal philosophy, and indeed all philosophy. He argues, following Quine, that there is no a priori truths, and that conceptual analysis, insofar as it purports to discover such truths, is just armchair philosophy based on the philosopher's intuitions, where there's no reason to assume that these are shared by others. This is not the time to consider that critique at length. Suffice it to say that Leiter's critique appears to allow, indeed to assume a concept of law, if only at a rough folk level, which seems to leave the door open to the possibility and possible value of analyzing that concept. Now, I note here that Brian, at least in today's paper, tried to foreclose that, but that's a debate for another time. I assume at some point he'll host a conference at Chicago where all the naturalists and anti-naturalists can get together. But for now, we must move on. It is a central assumption of modern theories of social practices and institutions, at least for hermeneutic or Verstehen approaches, as contrasted with purely behavioralist approaches, that since social practices are established to serve some human purpose, a reference to and focus upon that purpose is valuable and perhaps necessary for a proper understanding or explanation. And it is a commonplace that for many purposive activities, having the purpose in mind is necessary and central to understanding them. For example, one can imagine two people throwing a ball back and forth, where alternatively, A, they might be doing this just for the joy of throwing and catching a ball. B, it could be a competitive game where one wins by making the other person miss. Or C, it could be a cooperative game where the objective is to see how many times the ball can be thrown back and forth without either person missing. There is an obvious sense in which one cannot be said to understand, either fully or adequately, the activity one is watching if one does not know which of these three characterizations, which of these three purposes was correct. Perhaps then it is a natural step to believe that even complex social practices like law are best understood by focusing on the objective or objectives that they seek, or the ideals at which they aim. There are a number of prominent legal theorists who have built their legal theories on some variation of an ideal, a paradigm, or objective. And a brief overview follows of 6 prominent legal theorists that seem to partake of this approach to a greater or lesser extent. First, Nigel Simmons. Simmons argues for an archetype approach to legal theory. His arguments for this approach include the claim that such an approach allows theorists to account for the different and seemingly contrary uses of the term law. In particular, it allows the theory to account both for a value-neutral sense of law, in which legal rules can be used for both morally good and morally bad actions, and a value-laden sense such that significantly immoral rules do not warrant the label law. Additionally, Simmons argues the theory would allow an archetype theory would allow the theory to include laws of nature with positive laws within some broader theory of all laws. Simmons refers to the idea of law. By this he means the archetype against which systems are determined to be, however imperfectly, legal, and against which all systems are judged. For Simmons, this is necessarily a moral idea, for the practice of law pervasively involves its use in the justification of state coercion. And so the proper question is, and here I'm quoting Simmons, what must law be that it can justify the use of force? End of quote. Simmons' position might be seen as a bridge between conceptual and ideal-based approaches, a theory that can both focus on the concept of law and also to see the way that the concept works within our practices, and to see how our beliefs about law structure our practices. One might also note here John Finnis's notion in the course of commenting on Simmons's works. Finnis offered an interesting different reading, not so much law as idea, as laws as ideas. Legal rules begin as ideas, as objectives, as reasons. And only if this origin is understood can laws and also law be understood. We will consider Finnis's own approach below. Secondly, and briefly, Mark Greenberg. Mark Greenberg, in a series of recent papers, has challenged conventional assumptions underlying most analytical legal theories, in particular challenging the assumption that social facts and practices can determine the content of law without the addition of value facts. Along with this important critique, Mark Greenberg has also presented a positive view of law, in which it is in the nature of law that legal systems are, here I'm quoting, supposed to operate by arranging matters so that for every legal obligation, there is a moral obligation with the same content, end of quote. Here there is a seemingly clear connection between the theory of the nature of law and the aspiration all legal systems have or are said to have. Again, this approach Again, under this approach, law is best understood in terms of what it does when it is operating at its best, an event which may be rare to the point of never occurring, but it is still the objective towards which legal systems allegedly strive, and which the morally very best legal systems sometimes approximate. Thirdly, Robert Alexy. Alexy argues that to be legal, an individual norm or a system of norms must, quote, claim correctness, unquote, and that a legal system or legal norm that did not succeed at being correct or authoritative would be, for that reason, defective. This claim of correctness carries obvious parallels to Joseph Raz's well-known claim that by its nature, law necessarily claims authoritative status. However, while Raz takes this point as consistent with his exclusive legal positivist theory, Alexy believes that his version of the same claim requires an anti-positivist conclusion. I have argued elsewhere that Alexy's analysis confuses a general point about language and advocacy for something peculiar to or essential to law. If one is trying to sell, persuade, or encourage, one uses positive language. To not in some sense claim correctness in any context that calls for support or persuasion is at least initially paradoxical. There's a famous paradox from philosophy of language where one says, the cat is on the mat, but I do not believe it is. This is a point about language and rhetoric, not about law and morality. Alexy might respond that even if his correctness thesis is not distinctive to law, it is nonetheless essential to law. However, I am not sure that even this is supportable. What if a country were to say in its constitution or in some other official forum, we have no time for so-called justice. That is the talk of weak countries. Our nation is all about commercial efficiency and doing the best we can for the citizens of our great nation. Would a country's public dismissal of justice mean that its rule system would not warrant the label law? I, for one, am not convinced. Alexy might respond, surely a government or rule system that does not purport to be doing something, to be following some theory or purpose, cannot be characterized as legal. But this brings us back to the comparison with Rawls's idea of law's claim to legitimate authority, and the observation, Rawls's observation, that such a claim need not entail either any objectively grounded claim that the legal system in question has succeeded at being a legitimate authority, or any conclusion that the system is legally or conceptually defective, as opposed to being, say, morally defective, if it fails under some objective test of correctness. What is the basis of the grounds of Alexy's conceptual judgments and for his analytical claims? The basic analysis seems to be an inquiry on when and whether an ascription of legal status or legal character would seem absurd or contradictory, an inquiry in which reasonable commentators could, and likely would and likely have, differed. Fourthly, Lon Fuller. Lon Fuller is an American theorist who wrote in the middle decades of the 20th century. He was best known among legal theorists for his procedural natural law theory, built around what he called the internal morality of law. Fuller's internal morality consisted of 8 principles of legality, a list that is a mixture between what others call the rule of law or procedural justice and basic advice for effective lawmaking. Sometimes Fuller described the 8 principles as minimal criteria a system must meet to be a legal system. At other times, he wrote of different systems being legal to different degrees, and that some of his 8 principles, like the one regarding avoiding retroactivity, are more an ideal to be sought than a standard that's likely to be met. At times, he wrote of how law should be understood in terms of the tension between order and good order. Fuller's theory partakes of an ideal theory in the way he ties the existence of law to meeting, or at least aspiring to meet, requirements of procedural justice, even if, as Fuller himself concedes, this can be consistent with significant substantial injustice. Fifthly, Ronald Dworkin. Within Dworkin's interpretive approach, the relationship between theory of law and ideal of law is arguably unique. While most analytical legal theorists would insist on a sharp division between a theory of the nature of law and a theory of how to resolve particular disputes within the legal system, for Dworkin there is no such division. And the ultimate purpose of law plays a role in resolving particular legal questions. Dworkin's theory occupies an important intermediate role for the purposes of this paper. According to Dworkin, the proper approach to understanding law and other social practices is constructive interpretation, involving the making of an object of interpretation the best it can be of its genre. This connection with ideal-focused theories of law is thus indirect. One objection sometimes raised against Dworkin's approach is that it sees law through rose-colored glasses, rather than seeing law as it is. His response was basically that there is no law as it really is, separate from interpretation. The pre-interpretive data are merely isolated decisions of officials that require form to be imposed upon them to have any useful sense. And interpretation must be responsive to the point of the practice. Lawyers and judges know that claims about what the law is inevitably involve some amount of interpretation from the data points of statutes, judicial decisions, and the like. It is rare to have a case whose facts fit perfectly within the language of some statute or recent court decision. And even when one has an authoritative legal text that appears to be directly on point, one must still consider the possibility that there are other legal norms that might require the case or the statute to be read differently from the apparent clear meaning. Under Dworkin's analysis, all claims about what the law requires are thus interpretations of past actions by state officials, constructive interpretations sensitive to the purpose of the practice. And since the purpose of the practice is, as Dworkin sees it, the justification of state coercion, then the interpretation of past official actions must be as morally, politically good as possible. Under Dworkin's approach, it is not so much the theory, but the act of legal interpretation prescribed by the theory that aims at an ideal. Finnis. John Finnis is the foremost theorist of our time applying the natural law approach to law and legal theory. In an early chapter of his book, Natural Law and Natural Rights, Finnis cites with approval an Aristotelian approach to definition and explanation, in which social practices like friendship are given a focal meaning, which describes the central case of the practice. Arguing that this is also the best approach to theorizing about law, Finnis contrasts the approach of Hans Kelsen, which Finnis characterizes as seeking, and here I'm quoting, the lowest common denominator, unquote, of all instances of law, seeking those characteristics that are present in all instances of law or legal systems. There is a second sense in which Finnis's view is relevant to discussion of legal theories focused on ideals, teleologies, or paradigms. Excuse me. Finnis, in a number of his works, discusses the way that reasons should be understood in terms of good reason, and views of practical reasoning only from the perspective of one who is most practically reasonable. Finnis writes, and here is a long quote from him, "Where the subject matter of the projective, descriptive, general account is some practice or institution devised by more or less adequate exercises of reason and addressed to the rational deliberation of individuals and groups, there will normally be no good reason not to prioritize those forms of the practice or institution which are more rational, more reasonable, more responsive to reasons than other forms of the same or analogous practices and institutions. The standard for assessing reasonableness for this theoretical purpose is, in the last analysis, the set of criteria of reasonableness that the descriptive theorist would use in dealing with similar practical issues in his or her own life." End of quote. For Finnis, the central case of law is a system which makes more determinate general moral obligations, solves coordination problems, helps citizens to achieve moral goods and the common good, and in these and other ways adds to our moral reasons for action. He has argued that the theory of law must be true to the objectives of the practices, the good or goods being sought through the practice, and the evil the participants hope to avoid through it. On to the third section. Law has multiple aspects, which are sufficiently different that this may explain the difficulty, indeed perhaps the impossibility, of any single theory capturing law adequately. The corollary is that a number of quite distinct approaches manage simultaneously, each to give insight into a part of the law, even if not the whole. Each, in a sense, does talk past the others, so that no real engagement in debate occurs amongst competing theories. John Finnis has written of law's double life, that law is both the history of past political actions and the use of those past political actions supplemented by other considerations in resolving disputes. Law in the first of these two senses is primarily descriptive or historical. Law in the second sense is primarily prescriptive. In other writings, Finnis described his approach as asking not, "What is law?" but rather, "Why is law?" And I think this captures a similar contrast of aspects, while also highlighting the teleological aspects of Finnis's own theory. What is law is the descriptive side, focusing on a particular sort of process or institutional structure. Why is law, for Finnis, shows the way in which creating a legal system, and a certain kind of legal system, responds not just to a moral ideal, but in certain instances to moral requirements or prudential needs. A third overlapping way of seeing the same sort of contrast is the difference between seeing law as essentially a kind of social institution and seeing law primarily as a form of practical reasoning. I think this may echo Jules Coleman's discussion earlier about whether you contrast law as being primarily connected to social practices or primarily connected to moral reasoning, though it's a somewhat different distinction. That law can be shown to have both aspects, a sort of wave and particle duality, may go a long way to explaining why theories as different as legal positivism and natural law theory can both appear to capture basic truths about law. Returning to the primary theme of the paper, what are the arguments for and against seeing an institution like law in terms of its ideal or its objectives? One ground for such an approach goes to a basic point at the heart of modern hermeneutic-style social theories. As noted earlier, the argument that theories about the social practices and institutions need to be different from theories, for example, in the physical sciences, for the reason that social practices are established and maintained for some purpose. It is then a seemingly short and easy step to say that theories of a purposive enterprise should focus on that purpose, including or especially when the purpose is an ideal towards which the practice is striving. On the other hand, the viewing of objects in terms of some ultimate goal or perfect formation seems to invoke a classical Platonism, with the forms or ideas, or the teleological analysis found in Aristotle's work and some medieval thinkers, all of which were long ago rejected by mainstream philosophy, at least secular philosophy, and at least for human beings and social practices. Even a more modest purposive analysis would need to consider the objection that law serves many purposes, none of which could be said to define law. Indeed, as I note in a footnote, Michael Moore took on the project at one point of trying to offer a natural law-like functional kind of analysis of law, but in the end rejected the notion, or at least gave it up temporarily, believing that there was no single definitive purpose to law. In the classical and medieval works in the Western tradition, from Plato to Aristotle to Aquinas, it is most common to see law considered as a subtopic of a more general discussion of political theory or of moral theory or even of theology, a tradition that continues through most of the great European Enlightenment thinkers as well. Arguably, it is only with John Austin in the 19th century and comparable figures in the continental Europe that there is a strong push to refer to a study, a science of law, consciously separated from political and moral prescription. There is a sense in which the approaches to law, like those of Nigel Simmons and, to a less clear extent, John Finnis, seek to return theories of law to being segments of larger theories of politics or morality. And Simmons is explicit on this point, and here I'm quoting. This book, that is Law as a Moral Idea, is an effort to push jurisprudence back towards those more unified models of inquiry that preceded the so-called analytical jurisprudence as a distinct enterprise. End of quote. With Finnis, it is more a questioning of theoretical objectives other than the determination of how law fits within practical reasoning and our moral reasons for action. At one point, Finnis declared that legal positivism's claims are all either trivial or matters competent lawyers have always known. What arguments can be brought against the construction of theories of law around ideals, objectives, or teleologies? One standard objection is that while references to objectives and ideals are worthy of investigation, they are extraneous to determining the nature of the object or practice. As John Austin put it almost 200 years ago, law as it is needs to be separated from law as it ought to be. However, this sort of response, without more, simply begs the question. If the true nature of law is best understood relative to an ideal or an objective, then one cannot separate law as it is from law as it ought to be. There is also an intuitive sense that an object, entity, practice, or process can and should be understood separately from the standard by which it is evaluated. The definition of human being is rarely thought to take in all of morality, or even all of the particularly apt types of moral thinking like virtue ethics, built around a view of ultimate human flourishing, or the types of natural law theory grounded on a view of human beings placed in some divine plan. This does not deny the importance of evaluation or the connection between the standards of evaluation and the nature of the object, practice, or process to be evaluated. At the same time, one must take seriously an argument like Finnis's, that one can only understand argument if one understands what a good argument is. There are objects and concepts which seem explicable primarily through their highest or most perfect instantiation, even if such perfection is unlikely ever to be seen in the actual world. A different objection is grounded in what may be the dominant current approach to theories of law, conceptual analysis. If what we are investigating is, as a growing number of theorists, though not all, claim, if what we're investigating is our concept of law, the category within our society's interconnected collection of concepts that sets the dividing line between law and not law, what reason is there to suppose that the concept will pick out the best or most developed version of a legal system? To the contrary, it would seem like the criteria of our concept would be much more likely to do exactly what John Finnis, criticizing Hans Kelsen, denied. It would pick out the lowest common denominator, that which is true of all legal systems, by definition, as it were. Finnis's response is that a concept of a practice like law would apply focally to the fullest instance of the practice and non-focally to secondary, marginal, or defective instantiations. Part of the question is how broad of a subcategory is the central or focal case, and how narrow is the exceptional or residual category of marginal or defective cases. For Finnis, the focal case of law is a form that approaches an ideal, legal systems which practically reasonable people would judge in a practically reasonable way to be creating new moral obligations through the promulgation of positive law. In response, one might agree that concepts do, and therefore theories should, refer to central cases. But by that mean the large range of the average and the near average, excluding only the rare instances of extremes of different kinds. In the case of law, the central cases would arguably be the large range in the statistical middle of instances, likely including many forms of legal systems that frequently fall far short of what the moral, that is, practically reasonable citizens would want from their legal system. A separate point, of course, is that the range and operation of our concepts is, in principle, both contingent and a matter open to investigation. In the end of the previous paragraph, I made my own armchair speculation regarding our concept of law, but perhaps a more careful investigation should be made. H.L.A. Hart reminds us that there is a need and a value to theories whose purpose is the description and analysis of a particular kind of social practice. Additionally, there is also the reasonable fear, expressed by a wide range of theorists ranging from Hart to Fred Schauer to Peter Gable, that theories too tied to ideals will lead to the legitimation of unjust practices. By way of conclusion, at the most basic levels of legal philosophy, there is a pervasive disagreement. Is there some truth about the nature of law, or can we choose the theory of law which best suits our purposes or which has the best consequences? And are our theories about law at their most basic about concepts, practices, or reasons? Are they most essentially descriptions of criteria of an existing concepts, constructions of the most useful concept, or discovery of an ideal or a paradigm? While this paper does not attempt finally to resolve these questions, it attempts to canvass the factors that must be considered in selecting among the alternatives. There are various purposes that theories about the nature of law can and do serve. Conceptual analysis identifies the necessary terms of our concept law, setting its boundary lines. To the extent that the concept is, as Rawls argues, part of our collective self-understanding, theories of the nature of law may also allow us to understand law better by seeing the internal connections among our concepts. Even a fairly broad and general concept will set up a distinction between conventional cases and marginal or degenerate cases. One could also present a narrow concept that picks out the highest or morally best version of some practice. this narrower or best or paradigm concept certainly would be central to a prescriptive theory. However, the case for a paradigm case theories entirely supplanting an analytical or descriptive theory have arguably not yet been made out. While theories that disclose necessary and sufficient conditions and the connections amongst our concepts go some distance towards explaining the object or practice that the concept names, one might argue that there is plenty of explanation left to do and a role for different sorts of theory. Some of these supplementary theories will come from other disciplines, like sociology, anthropology, and history. Others may come from within philosophy, including its sub-branches of moral and political theory. Some of the ideal theories can indeed be seen as bringing legal theory back to its roots as subordinate to a broader political, moral, or even theological system, as contrasted with theories that focus on law alone, whether one characterizes such a theory as scientific, social scientific, or the like. Even if an ideal makes sense of a practice in a way that one might otherwise miss, one might still argue that a theory that focuses analytically or descriptively without recourse to ideals has independent value and significance. Perhaps the difference between central cases and ideal cases of friendship and one's concept of, or theory of law is that in the case of law, highly imperfect and significantly non-ideal instances numerically predominate. Some might argue that fully just legal systems are in fact never seen. One need not deny that law aspires to an ideal. It is perhaps sufficient to note that law aspires to many ideals, and that this can be seen in the theories of law themselves. Thus, while Ronald Dworkin argues or assumes that law is primarily about justifying state coercion, other theorists argue that it's primarily about guiding behavior. While many theorists believe that law aims at justice, the law and economics theorists assert that it aims at efficiency. There is a multiplicity of both purposes and aspects within law. Law as reason and law as social theory, and law as historical record of official actions as guide for decision making. This multiplicity that may explain why quite different theories each seem to capture basic truths about law, and why we might never find the one right or best theory. Thank you.
Thank you for this rational speech, not irrational.
I'll do the irrational part during the questions.
Okay. Yes, please.
So, Brian, you make it seem as if the best explanation for why one would impute ideals or purposes or ends or aims to the law is that one is taking a hermeneutic approach to the law, or that one sees law as being continuous with theory of practical reasoning or something like that. And that may be true for somebody like Finnis, but I mean, for many of the other people that you mention, and you left out, I mean, Joseph Raz, for example.
Well, I mentioned Raz. I take him as not being an ideal-centered theorist.
Except that he imputes a moral goal to law.
A moral claim, but not...
No, not a moral claim, a moral goal.
Yeah.
I just discovered this last week in the 2003 article to the one in the new collection. Anyway, trust me, it's there. Personally, I think that law has a moral aim, and people like Mark Greenberg, Ronald Dworkin. There was another person I saw.
Nigel Simmons.
No, not Simmons. Anyway, Alexei. I think that these people actually are doing some form of conceptual analysis that they think that the proper analysis of the laws is something which has a name. So for example, hearts have functions, and that's not because anyone's taking a hermeneutic approach to hearts. So epistemologists think that belief has a name, namely the truth. Names purport to refer. I mean, this is, clocks are supposed to tell time. I mean, these are attributions of aims, ideals to objects which come about just because of an understanding of what kinds of things these things are, and they involve no particular, like a deep methodological commitment to any of the things you mentioned. Now, I'm not denying that maybe some people, they are talking past each other, but they may be actually doing the same thing, just coming out with different positions. And I think we ought to take that seriously, and I worry that your approach doesn't take that seriously enough.
No, it is a good point, at least certainly to the extent that it shows I need to be more precise in my categorization. I'm not stating that law is, or that anyone claims that law is something we just happened upon, and there it is out there, this strange practice out there. I repeat throughout, law is a purposive activity. It's there to achieve some goal, and I'm happy to admit with Rawls and others, and that part of the goal most legal systems have can be characterized at least as partly moral, and whether it's entirely moral is neither here nor there. What I was focusing on in the paper are not. I'm not antagonistic to theories that claim that law is a purpose. I'm questioning the theories that go a step further and ground the theory from the starting point is the ideal. To what extent does it reach the ideal, and to what extent it doesn't reach the ideal, it's not fully law. And of the 6 people I discussed, it fits them some better than others. You're shaking your head. I think there's room to clarify. There's simply the point that there's a difference between what someone like Alexei is doing and what someone like Rawls is doing. The difference between the grounding on the ideal and the extent to which the ideal is met, and grounding on various other aspects of the concept, including perhaps the attempt to reach the ideal, but without any attempt to say that the failure to reach the ideal makes it a lesser or defective form. But we may need to talk about this more. And now to the dinner.
Well,
There's
first,
one hand.
okay,
There's-
no more questions?
No, there's one.
Yes, there, please.
Yes, Brian. So sometimes it seems to me problematic to. Hello? Yes.
Yeah.
Sometimes it seems to me problematic to do the kind of project you want to do with the notion of ideals or the view that there is something beyond our practices. And I thought that the most successful strategy probably is considering what actually Finn is considered in the first chapter, but does not develop it, because he focuses so much on the formation of concepts. But I think that probably the most successful strategy is considering exactly what the man of practical reason does. So focuses on action rather than on theory, on ideals. So I just wonder what you think about this, because all these projects seems to me so counterintuitive. The question is, well, how can all these things guide action? Yeah.
Yeah, well, it's a point I've mentioned elsewhere and at a little bit greater length. it seems to me one way to understand the disagreement between legal positivism and natural law theory is that legal positivism focuses more of what Hart says in the postscript. There's a need for a descriptive social theory of a certain type of social practice. Here's a social institution, let's describe it. While the natural law theorists focus more, as you point on practical reasoning. What should, as Finnis says in the title of his article, what should I truly do? What should I do? And to what extent does law fit into part of what I should do to help build a moral society? And then later, in what way does law, or at least good law, affect my moral reasons for action? And it seems to me that the focus on practical reasoning and the focus on doing a certain type of social theory lead you in different directions that may overlap to some extent, but not entirely. I can't
Yes. I think probably more unpacking the concept of practical reason. People talk about practical reason, but there's no an unpacking of the concept.
So how would you unpack, practical
But
reasoning,
in terms
most
of
people...
intentional action, what intentional action is, there are two big theories of intentional action. One, the more Davidson type, that presupposes that intention is a mental state, and another one that conceives the intention not as a mental state, but as the will linked to an object, to a goal. So Moore started with a much more modest project rather than,
And how would
this aim of law that aims morality. And I don't know, people, people cannot grasp that. And I think it has difficulties, I think.
Okay, well, you'll have to explain to me further in person or by email how the different understandings of practical reasoning lead to different theories of law, but it's not immediately clear to me this late in the day after lunch.
Brian, two quick questions. I've been wondering for some time, what exactly is our concept of law? Who are we? Is that the people in the Western world, or what is it? Second is, how do you see the relation between, the concept and the nature of law? Is it the problem? What we should? I take it you're suggesting that we should, in our inquiries into the nature of law, analyze the concept of law. Do you have anything to say about, the relation between the concept and the nature of law?
Small topics. So the idea of our concept of law is something that's been used both in Joseph Rawls's work and, if I'm remembering correctly, Jules Coleman's work as well. And so the question is, who is this we? There's a series of American jokes where these two characters, one has a Native American sidekick and they're surrounded by other Indians, and the Lone Ranger says, what should we do, Tonto? And Tonto says, what's this we, Kimosabe? We would have to be whoever it is who shares the series of concepts. Now, the question, it's a good question for this conference, and was brought up partly in Scott's paper, is the American understanding of law in the early 21st century the same as that in Sweden or in Spain, or in Nairobi, and how is it the same as it was, 50 years ago? And in principle, part of the theory of the concept of law would have to, once you delimit, it would be open for someone to say, well, that's not my concept of law. And Rawls himself leaves open the possibility, a little frustratingly, as to whether a given community might have more than one concept of law, in which case you're left with Stephen Perry's question of how do you choose amongst concepts of law other than through moral evaluation. The question about the connection of concept and nature of law is one Scott got into, and I don't think my point will be much different than his, which is the concept in part is the limits. Why do we call something law and why do we call something else not law? Now, the nature of law will be partly that, but partly something further, what I think Scott called as the implications, or sometimes he called the essentials, is that given that law has these characteristics, certain things may follow. Now, the certain things that follow are not, in the narrowest sense, part of the concept of law, but they could be part of a philosophical investigation that follow from the attributes of law.
Yes.
Professor Bix, I have to tell you, I'm maybe one of those who really appreciate the kind of endeavor that you're doing. I think that this kind of
Good to have one fan.
yeah.
Yeah, well,
This
you and my
kind of-
mother, so.
This kind of synthesis, and I think you're giving the bigger picture, and that could help us not, get out of our petty disagreements about some conceptual issues or, just unproductive kind of disagreements. I'm going to continue the discussion that you were just following. Let's imagine that every community will, legal theorists from all around the world, we're going to meet in 10 years in Girona, and we're each going to present our concept of law. And let's say that we might have, perhaps representatives of civil systems will have minor disagreements, but they will, reach a compromise, would get to a more general form, etc. But what do you think it's going to happen in the end? Do you think we're going to start talking past each other? Do you think we're going to be able to reach a final agreement on the universal or oral world's concept of law? And in that sense, then the issue of ideals and of the purpose of the law, perhaps we will disagree less on the purposes of the law and more on the concept of law, of what law is.
Thank you, especially for the kind words at the beginning. A few things. One is, one drawback, definite drawback, and I've written this before, one definite drawback to this Rawlsian our concept of law that I have largely bought into is one thing it definitely does not explain. One thing it definitely does not explain is if this is a fair characterization or interpretation of what we do, and I think most of the time it is. It doesn't explain why people get such heated views and so upset. No, you're wrong. The concept of law isn't this. The law isn't this. It's that. If it's just about our concept, well, maybe you're right. One wants to be right about everything, but I'm wrong about the concept. Okay, who cares? It's not the worst thing in the world. So whether there is something more at stake, certainly people act as if there's something more at stake. So when people would all get together in 10 years and to bring their own concepts of law, one response is, that's interesting. It's interesting that, your concept of law and includes this, but mine doesn't. It could be just an interesting sociological, anthropological gathering. But one thing Rawls notes is he says, our concept of law is not some Platonic idea. It's contingent, it's parochial. It changes over time. Going back to Torben's question, our concept of law is likely different than the concept of law in our same community 50, 100, 200 years ago. And another thing Rawls says is one thing that can change it, he doesn't emphasize this, is having the wrong theory of law. If you publicly proclaim the wrong theory, that could affect what your concept actually is. So even though Rawls himself doesn't believe that concepts are something we should produce or modify for the best social consequences, the intended or unintended consequences of this discussion might be that it might have the effect of changing our concept over time. Now, this gets into a different question. This gets into the Fred Schauer, Liam Murphy territory where, concepts of law are something we should try to change, we should try to affect to have the best consequences. I'm not sure what consequences, this is a large gathering, but even if all of us left this room, with Jules Coleman's new approach to the concept of law, I'm not sure how much effect in the real world it would have or should have. I mean, we're just legal theorists. And even the ones that get appointed to the Seventh Circuit, don't have that much, Richard Posner and Frank Easterbrook are judges now. And they do a lot of damage, but generally not through their theories of law. So I'm not, I think it would be an interesting discussion. I'm not sure it would have further consequences.
Yes, please.
Thank you for your paper. It's a short question. If the law is something like a functional kind, then
Something like a natural kind?
a functional kind,
Okay.
then we have the problems of definition of a delimitation of function objects. For instance, is an elevator an elevator out of order? Is a pen which doesn't write? Is a chair a broken chair? I think so, yes. And if the answer is yes, the law is law, even it is not a central case of law, it's an unjust law, I don't know. No? What do you think about?
Yeah, well, this picks up aspects of John Finnis's work, Mark Murphy's work, to some extent Lon Fuller. It may not make that big of a difference if, Finnis says this is law and it's, the central case or its, fullest form. And the other things are law too, but they're law in some, lesser sense or some defective sense. Is that different from saying law is law, whether it's, the differences between the legal positivist perspective and the ideal form perspective may not be that great or that significant. I think you're right.
Well, before you leave, I must inform you that there will be 2 buses at 8:00 p.m., one in Plaza Catalunya and the other one in the Hotel AC, to the departing to the Dali Museum and the closing supper. And second, I would like to ask Dr. Ana Maria Gelli and Dr. Moreso, and Dr. Elena Lauroba to come to the end. Thank you very much for your speech.